Welcome to Forensic Perspectives, the legal community's online resource for the latest in forensic accounting, business valuation, and financial litigation support. Your host for this podcast is Mark Gottlieb. In addition to being a certified public accountant, Mark has also obtained many professional accreditations in forensic accounting and business valuation. As one of the Tri-State's leading financial experts, Mark is also a frequent lecturer and writer. Without any further ado, please welcome the host of Forensic Perspectives, Mark Gottlieb.
Thank you, and welcome to today's broadcast. In Daubert versus Merrill Dowd Pharmaceuticals, the court concluded that the trial judge must act as a gatekeeper for expert testimony, considering several non-exclusive factors applicable to the testimony's reliability and relevance. Although Daubert focused on the admissibility of scientific expert testimony, it has had great impact on the financial expert testimony as well. In another case, Kumho Tire versus Carmichael, the court made it clear that the gatekeeper functions apply to all expert testimony, not just one of scientifically based. Thus, under the rule announced in Daubert and expanded in Kumho, the courts must ensure that experts will offer testimony that is sound and relevant to the factors of the case before admitting their expert testimony. In recent years, challenges to the financial expert testimony have increased significantly. Since Daubert, an increasingly number of testimony experts have been subjected to challenges by opposing counsel in an attempt to prevent experts from testifying. However, many prominent members of the legal community in recent years have acknowledged that with the rapid increase in financial fraud cases and complex divorce cases, the admissibility of the expert's testimony needs to be significant. Nevertheless, attorneys will continue to make frontal attacks on experts' credibility at any time. Just like attorneys, expert witnesses, especially financial experts, have their own style and personality. As such, for good or bad reasons, the effectiveness of a financial expert may vary depending upon the outcome of cross-examination. This leads us to today's topic, cross-examination of a financial expert witness. I'm happy to welcome attorney Mark Sobel. Mark is the co-managing partner of the law firm Greenbaum, Rowe, Smith & Davis, located in Roseland, New Jersey, and is the chair of the Family Law Practice Group. Mr. Sobel's professional distinctions include being listed in the Best Lawyers in America Family Law category, listed in Super Lawyers New Jersey edition in the family law practice area, and selected by Best Lawyers as their best family lawyer in New Jersey. Mark has also served as the managing editor of the New Jersey Family Lawyer and is involved in a variety of charitable activities, including supervision of the pro bono litigation support by his firm. Mark, thank you and welcome to Forensic Perspectives.
Thank you.
Before we discuss cross-examination of a financial expert witness, let's first talk about expert witnesses in general. What do you look for in an expert witness?
I look for somebody who can do a variety of things for me. Number one, I want them to help me construct the best type of case for the particular factual matrix. I want them to challenge me and give me some independent thoughts in terms of valuation technique, if it's a financial expert, or methodology, or problems with certain fair value methodologies that we might normally utilize. So I want them to be both a sounding board as well as provide some thoughts that we can pursue together as we formulate the case. I also want them to be the type of expert who will be clear, definitive, almost professorial when they're going to take the stand, but yet not so rigid that they will be inflexible during their testimony.
At what point in time do you look to hire an expert?
The first thing I would probably do in a matrimonial case is make a determination whether we need an expert. Chiefly in the financial area, there will probably be two areas. One is if we have a business that needs to be valued. The second is if we need to do some form of lifestyle analysis, which we have utilized accountants for the last probably 10 years. Underneath that, there are breakouts in terms of that, whether or not there might be some other things in terms of dissipation of assets or secreting of assets or tracing of assets or passive versus active assets. But the primary two groups of areas that I look for initially in a case are business valuation as well as cash flow.
When you're looking at a financial expert, do you consider their credentials?
I definitely consider their credentials. As the cases have wound their way through the system, and I've been doing this now for 31 years, sort of like in Casablanca, the usual suspects come to mind. There's a certain cadre of forensic experts that have developed a certain expertise within the court system that I believe are viewed by the judges as ones who know the business well and are looked to for guidance. Obviously, that's the type of expert you want. They have a certain already predetermined access to the court. But beyond that, one of the things that I think lawyers don't look at, which I tend to look at, is does that particular expert have some expertise in the particular business being evaluated? So if it's a hedge fund, have they done evaluations of hedge fund? Maybe not in a divorce case, and often not in a divorce case. Sometimes it's better. I had a car dealership case. Have they evaluated car dealerships and buy or sells so they can bring to the testimony at the trial that practical knowledge of I've been in these types of transactions before. It's not just a hypothetical case for me. That has a certain weight at trial.
Do you think that industry experience trumps valuation theory?
They go hand in hand. I won't necessarily say it trumps it. I think it elevates the testimony, it accents the testimony. But if you do not have good methodology and you're going to get destroyed under cross-examination because you just haven't done appropriate type of methodology in this forensic area, having expertise and giving somebody, the back of a sheet, the thumbnail type of analysis, it's not going to really carry the day. You really have to have both. So if you just had the expertise in the industry and it was isolated, that might not be enough for me in terms of being an expert.
And do you find that to be a difference if you're hiring an expert that's going to be questioned under direct examination as opposed to cross?
I always look for it both ways, but I really emphasize in my mind in terms of making the determination how they are going to do under cross. I believe I will be able to prepare my experts well. I think that the direct examination will go in fairly straightforward. The real emphasis is how they are going to do on the cross. Judges tend to listen to cross very closely. They think that's the search for the truth. They will pay a lot of attention to that. When you're doing the direct, oftentimes they're looking down at the report. They may be even reading the report. It's kind of rote, especially for judges who've been listening to this for a long time as you're explaining the different methodologies. But when cross comes, they sort of perk up just like juries do. And I want to make sure my expert can withstand cross-examination.
All right, let's talk about cross-examination for a moment. What is your initial intent when you are cross-examining a financial expert?
I think the best way to answer that is sort of to start with a negative, what it isn't. I am not going to battle with them on their turf. I will lose that battle almost always because it is their turf. Even though I've been doing this a long time and I'm pretty knowledgeable in the area, I'm still not a forensic accountant. I'm a trial lawyer. So I'm not going to battle them on their turf. What I am going to do is force them to battle me on my turf, which means we're in a court of law where I know the rules, I know the procedures, and I'm more versed in it than they are. So one of the first things I want to do is I want them to concede that everything they've done is subjective to a certain extent. Experts bristle at that a little bit, and they don't really have a sense that, that's not really affecting their, quote, credibility, but it is if they bristle with me or fight with me on that. So one of the first things I want them to acknowledge is all this forensic evaluation is an art, not a science. It has a lot of subjectivity, and I will get those parameters extended as far that reasonable minds could differ by X, by Y, by Z. So we start out at the very beginning of the cross-examination with the judge hearing, this is not precise, it has a lot of flexibility, it has a lot of subjectivity to it, and people can differ about it. It's a good way of starting the cross-examination.
I assume your adversaries flip the coin on you when they cross-examine your witness and your expert, that they try to do the same thing, to employ the same feeling that you're doing.
If they've listened to my lectures, I'm sure that they have, and that would be a wise thing to do. But that goes to the preparation of the direct. because I prepare my experts for that type of direct examination. And the way you prepare an expert for that type of direct examination goes along the lines of something like this. Yes, there is subjectivity involved in certain aspects of it, but it is within a defined scientific matrix that my experience tells me it's limited. So yes, there is some limited subjectivity involved in it, but it is not wildly subjective, which gets the expert, when they refocus on, yes, there's a certain methodology, there's a certain procedure, there are certain documents you look at, there's a certain way of going about it that is recognized, uniform, and approved. So while there is some subjectivity there, it's within a limited scope.
Now, if you are cross-examining someone, two things have already happened. Number one, there's been an expert report that has been submitted to the court, I imagine, and it's included as evidence. And then also there has been a direct examination of this witness. And so the witness has had probably an easy time expressing what he or she thinks are the pertinent parts of their report to allow them to formulate their opinion and for their opinion to be accepted. When you're cross-examining someone, what do you use as a roadmap? Do you use the direct examination, or do you use the report that was issued, or a combination of both?
It's a combination of both, but let me go to the preface of your question because it wasn't entirely correct. Number one, the expert report often is admitted into evidence. It is not evidence. It's hearsay. It's an out-of-court statement entered for the truth of the statement. So technically, under the hearsay rules, it's hearsay and should not be admitted as evidence. Some judges honor that. Most do not. And most judges will be very annoyed at you if you prevent them from admitting it into evidence because it's hard to follow the testimony without the report. The better way of dealing with that is to reference that, mark it for identification. Perhaps it goes into evidence, perhaps not, but let the judge read it along with the direct testimony. If I think the other side has done a much better written product than my side has done, I will have it admitted for identification purposes, fight that it doesn't come into evidence. Let the judge look through it, but I just do not want it admitted into evidence and become part of the record. So that's one subtlety. The other thing is, in terms of the direct examination, I oftentimes, prior to the direct examination, will ask the judge for a brief voir dire, which is to qualify the expert and whether I have any questions. Now, most of these experts, they're going to get all qualified. And even if they're slightly unqualified, the judge says, well, I'm going to take it for the weight of whatever it is. That's not really the purpose of the voir dire. The purpose of the voir dire is to give the judge a sense that there may be one or two chinks in this, especially if I've taken the deposition of the expert already, which I have. And I know that there may be one or two things that are important, and I want the judge to hear that before they hear any direct testimony. I know that the voir dire is not going to eliminate the expert, but the judge is going to hear that. So the judge may hear something like, you've never evaluated a car dealership before in your life, have you? Okay? And now I know he's going to get admitted, but now the judge knows this is the first time he's ever evaluated a car dealership. I want the direct testimony to be heard with that in mind. So that's an opportunity that an attorney should not pass on, even though they know the expert's going to get admitted. Now, to answer your question in terms of the way I go about it, one of the mistakes a lot of attorneys make is they don't listen to the answers on the direct examination. I listen to them, and if I think that there's some fodder there in the future, I write down exactly those words. But I never just follow the direct examination in my cross. That is not proper strategy. That's just reinforcing the direct, allowing the witness to say it again twice for emphasis. I have my own outline, which never really follows the way the direct goes. I don't want it to follow along. I want the expert to be unaware where I'm going next. I often go out of order. I often ask things I know I'm going to get him a little worried about initially. Then he's not going to be maybe as confident later on. I use my own deposition oftentimes to ask a series of questions initially when I know I've got him to make certain admissions in the deposition. And I ask those questions without looking at the deposition, looking at my notes, so that the witness doesn't know I'm reading from his deposition testimony. And if he deviates, then I'm going to confront him with the deposition testimony. It's a nice way to start cross-examination in front of a judge when the witness has already deviated from his deposition and you hit him with that deviation. So it's a combination, but I would say much more likely I have my own notes, my own outline. I'm prepared to do my cross without the direct.